Judgment in the matter of the Queen versus Copeland.
Lord Sales will explain the judgment.
This appeal is concerned with the interpretation of Section 4, subsection 1 of the Explosive Substances Act of 1883. Section 4.1 creates a criminal offence which requires consideration of two limbs. For the purposes of the appeal, these are, first, can the prosecution show that an accused person knowingly had an explosive substance in his possession in such circumstances as to give rise to a reasonable suspicion that he did not possess it for a lawful object? If so, the second limb is whether the accused person can show that in fact he did have it in his possession for a lawful object. In the circumstances of this case, it is agreed that the prosecution are in a position to satisfy the first limb. The question therefore arises whether the appellant, charged with an offence contrary to Section 4.1, can show that he had the explosive substance in his possession for a lawful object. The appellant is 22 years old. He has been diagnosed with autism spectrum disorder. At the relevant time, he lived at home with his mother. He purchased quantities of chemicals online and from these produced a small quantity of an explosive substance. He had this substance in his possession when a search warrant was executed by the police at his home. His explanation is that he produced this small quantity of explosive because he had developed an obsessive interest in military matters, including bomb disposal. He wished to understand how explosives worked and to experiment with them. In pursuit of that interest, he had already caused some small-scale explosions in his back garden, which he recorded on his mobile phone. His case is that he had possession of the explosive substance for a lawful object, which was to experiment and educate himself. He says that his experimentation would be so small in scale as not to cause harm to others or to their property. At a case management hearing in the criminal proceedings against the appellant, the trial judge ruled that experimentation and self-education to satisfy his curiosity in this way could not amount in law to lawful objects for the purposes of Section 4.1. Therefore, the appellant would not be permitted to present such a defence at his trial. The trial judge considered that he was bound by a decision of the Court of Appeal in a case called Riding to reach this conclusion of law. The appellant appealed to the Court of Appeal, which dismissed his appeal. It also considered that it was bound by the decision in Riding to come to that conclusion. However, the Court of Appeal certified the issue which arises on this appeal as a point of general public importance, so that this court could review the matter. By a majority judgment, this court allows the appellant's appeal. It holds that, as a matter of law, personal experimentation and self-education are lawful objects for the purposes of Section 4, subsection 1. That is indicated by the legislative background to the 1883 Act. It's also in accordance with general legal principle. As a matter of general principle, it is lawful for a person to do anything which is not prohibited by law. Neither statute nor the common law makes experimentation and self-education unlawful. Furthermore, Parliament did not intend to criminalise experimentation with explosive substances in schools or universities or for commercial purposes, and must have intended the same defence to be available in those contexts as well. The Riding decision was correct on its facts, but on a proper understanding, it does not cover the present case. So long as an accused person can show that he had possession of an explosive substance solely for the purposes of personal experimentation and self-education, he may have a defence. In this case, it was possible that the appellant would be able to show that he had possession of the substance solely for those purposes. He was therefore entitled to be able to present that defence at trial, where it could be tested in light of all the evidence in the case. The court made this ruling a short time ago, but reporting restrictions were in place until the criminal proceedings against the appellant were concluded. In the light of the court's ruling, the prosecution decided not to continue with its prosecution of the appellant under Section 4, subsection 1. At the same time, the appellant pleaded guilty to certain less serious offences in relation to these events. The criminal proceedings against him have therefore been concluded, and so this court is now able to lift the reporting restrictions.
Thank you. The court will now adjourn.